So good morning, colleagues. Welcome to the second day of Tokyo International Law Seminar. I think we're ready to start as folks pour in. So please allow me to introduce the first speaker of today. The lecturer we have with us today is Professor Philippa Webb. Professor Webb teaches public international law at the University of Oxford and specializes in public international law as a barrister. She appears regularly in International Court of Justice, international tribunals, and English courts. The topic of her lecture today is state official, and diplomatic immunities. Please.
Thank you, Midori-san. Good morning, everyone. I'm delighted to be here, and I'm looking forward to our two sessions together this morning. So the first session is on state official, and diplomatic immunities. I'm going to be asking you questions along the way, encouraging discussion, and please do ask me questions as well. And then our second session, after the 20-minute break, will be a fully interactive session where we're going to look at tricky, interesting, difficult cases on immunities and put ourselves in the shoes of the judge or the government official who is making the decisions about them. So today I'm going to outline first the concept of immunity, what are the values behind it, what are the principles that guide it. Then we'll focus on the immunity of the state and state officials. We'll then look at state immunity from execution, which is very much in the news these days. And we'll finish up with looking at diplomatic immunities, which are, have some parallels with state and state official immunities, but are governed by a dedicated convention, the Vienna Convention on Diplomatic Relations. So let's start with the overall principles guiding state and state official immunities. And this is a quote from the International Court of Justice, and I'm going to be referring to ICJ judgments throughout. And this is probably the key judgment on state immunities, which is the jurisdictional immunities case between Germany and Italy. And I'm going to be coming back to this case later this morning. And in this, the court made clear that state immunity is a rule of customary international law. It is not a discretionary principle. It's not something that states can choose to grant or take away from other states according to political or other motives. It is a rule of customary international law and derives from the principle of the sovereign equality of states, which, as the court said, is one of the fundamental principles of the international legal order. But having said that, even though we know this is a hard rule of international law, it's not a rule that is absolute. It used to be, but it has developed exceptions throughout time, and we're going to be really focusing on the contours of those exceptions in our discussion this morning. And I like the quote from Judge Youssef on the court, who said, state immunity is, as a matter of fact, as full of holes as Swiss cheese. So it is a rule, but it has many exceptions that apply in different ways and that are actually in dynamic movement at the moment. And we're seeing some of these exceptions expand and contract through various cases. So what are the sources of the law of immunity? Unfortunately, there isn't a one-stop shop for defining the law of immunity. You have to look at a number of sources. So we have a patchwork of treaties that govern this area. We have the 2004 UN Convention on State Immunity. However, that convention only has 25 parties to it, and it needs 30 parties to enter into force. We have the Vienna Conventions on Diplomatic Relations and the Vienna Conventions on Consular Relations. Those are very important. They are very widely ratified, but they only govern the immunities in those realms, diplomacy and consular relations. We have the Special Missions Convention, which governs special missions, which are short diplomatic visits between states, but that as well only has about 35 parties to it. So I can't tell you that there is one treaty on state immunity that you can turn to that will give you the answer. You have to look at other sources. So how do we define the rules of state immunity? We look at customary international law as well. We look at judgments, both of national courts and of international courts, of which the International Court of Justice is a very important source of these judgments. But we also look at scholarly writing. We look at the work of the International Law Commission. We look at the work of scholarly bodies like the Institut du Droit International, and we try to fill in the gaps in this area through those subsidiary sources. So throughout, I'm going to be referring to cases, I'm going to be referring to the treaties where they're relevant, but always to bear in mind that actually defining the rules and applying them in state immunity is quite a complex task because of this range of sources. Now, what about the purposes of immunity? Why do we even have this body of law? And we can bring it down to 3 principles that guide the development of the law of state immunity. And sometimes they will apply, all of them will apply in a case, sometimes one of them will be dominant. So the first one is this idea of sovereign equality. You saw that in the quote that I showed you on the first slide from the International Court of Justice. The rule of state immunity derives from sovereign equality. That means every state is equal. One state, one vote in the General Assembly. And what that means in terms of immunity is that one state is not allowed to sit in judgment on another state because they are equals, equal and independent. However, of course, if there is consent or an exception to that rule, then sovereign equality will give way to sitting in judgment. The second rationale for immunity is representation. The idea that a person should enjoy immunity from the courts of a foreign jurisdiction because they embody the state, they represent the state. So this particularly applies to the immunity enjoyed by heads of state, heads of government, ministers of foreign affairs, and diplomats. Another rationale is functional. The idea that we need immunity to ensure the smooth operation of international relations. If diplomats were always concerned about potentially a frivolous or malicious lawsuit against them, then they may be hesitant to perform their role to exercise their official functions in the proper way. So we give them immunity so that they don't have this concern about potentially being held accountable in a foreign court. But as we'll see, there are also some exceptions to that. So these are the 3 rationales that we're going to be seeing underlying all the cases in this area. So let's now turn to the immunity of states and state officials from jurisdiction. Now, as I said, this is a rule, not a matter of discretion. And we've had a movement from an absolute doctrine to what we call a restrictive doctrine of state immunity. Now, we call it the restrictive doctrine because it means immunity is restricted to acts in the exercise of sovereign authority. If the act of a state is in its sovereign authority, it will be immune. It cannot have a foreign court exercise jurisdiction over it. However, if it is an act of a private law or commercial nature, then it's not immune. That's the restrictive doctrine. And that means it can be held accountable, that a foreign court can exercise jurisdiction over it. Now, this is a very nice-looking, neat table, but in practice, it can be quite difficult to identify what is an act of in the exercise of sovereign authority and what is an act of a private law or commercial nature. So let's have a look at a case that explores this. Is buying fighter jets a commercial activity? If you think it is, then that means that the state will not be immune. If you think it's a sovereign activity, then the state will be immune. So let me give you the facts, and then I'd like to get some views from the group on whether you think this is an immune activity or not. So this is a real case. South Korea agreed to buy 40 fighter jets from Lockheed Martin in the United States for $7 billion and a military satellite from Airbus for $3 billion. The claimant in this case was a private individual. They were the person brokering this deal. Now, this purchase was regulated under US law as a foreign military sale, and it needed the approval of the Department of Defense. At the last minute, South Korea cut the broker out of the deal and directly dealt with Lockheed Martin to make this purchase. So the claimant sued them in US courts. So they sued South Korea saying that they had breached the contract, that this was a business tort, that there was antitrust violations. So we have a very commercial case before the US courts against South Korea about this purchase. Is South Korea immune? Can I get some views? We've got microphones that can move around the room. Don't be shy to share your views. Yes, thank you. Is there microphones coming?
My opinion is yes.
That it is immune. And why? This is a commercial transaction for billions of dollars involving a private military company and a private broker who was cut out of the deal. So what makes you think that this is immune?
State sovereignty and perhaps national security.
National security? So these were military purchases, so there could be a national security element.
Yeah.
And why do you think that's stronger in this case than the commercial elements? Is it because it's a fighter jet and not an ordinary plane, or?
Exactly.
Yeah. Okay. Other views? Yes, over here. A microphone is coming.
Thank you. It is Abdullah Al-Qusayr from Saudi Arabia.
Yes.
Just if South Africa bring this one to court.
South Korea or
South Korea, sorry.
Yes.
If bringing that to court, is it still immune because they brought it to the court? So they kind of.
Well, South Korea did not bring it to the court.
Okay.
The claimant, the broker, brought it to the court. But you ask a very good question, because if we flipped it, say the deal went wrong and they weren't happy with it, the amounts were different from what they thought, and South Korea brought it to the court, what was the point you were going to make?
They are giving up with their immunity.
Exactly. They've submitted to the jurisdiction. So yes, if it was the other way around and South Korea brought the case, then there wouldn't be immunity because they've submitted to the jurisdiction. But in this case, they were resisting the jurisdiction, and it was the claimant, the broker, who brought the case. So do you think buying fighter jets is sovereign or commercial?
It is sovereign because it is on behalf of the state, and the commercial side of it, it's kind of be like restricted.
Yeah.
You can't like sell it later, unless there are like some certain conditions and.
Yeah. Okay. Thank you. So I'm going to tell you what the US court said, and they agreed with you. So you're thinking like the US judges of the Fourth Circuit, in that they agreed this was an immune transaction. South Korea could not be sued. They said it was on its face a commercial deal. It was about the purchase and sale of goods. That's commercial. But the nature of this transaction, the fact that it was fighter jets, national security, military hardware, meant that this was a transaction peculiar to sovereigns. It was a sovereign activity. And they made the point that a private citizen cannot buy a fighter jet. I'm not sure if that's entirely true, but their point was that a private citizen would find it at least very difficult to buy a fighter jet. And this was a heavily regulated purchase. So like your point, various conditions had to be fulfilled. The Department of Defense had to approve it. All of those features moved it from a commercial-looking transaction to a sovereign activity. However, there have been other US cases where it's involved the purchase of military aircraft, for example, by Iran, or a contract to repair fighter jets by Saudi Arabia, or the purchase of military equipment by Hungary, where those US courts have found that those transactions were not immune. So it just shows you it really depends on the facts of this case. And in this case, because there was that requirement of approval by the Department of Defense, it moved it into a sovereign activity. Now, the claimant here appealed to the US Supreme Court, and the US Supreme Court denied review of the case. So this now stands as the precedent, at least in the Fourth Circuit of the United States. Okay, let's continue to explore the line between sovereign and commercial activity. And this time, we're not looking at purchases, we're looking at contracts of employment, and where workers, usually workers in an embassy, are suing the state because they are dissatisfied with their treatment. Now, these are two recent cases in the UK, and they've got some interesting facts that make them, I think, quite tricky to define the line. So the first is a case where the US Embassy in London was being sued by a person who worked as a chauffeur. So he worked as a chauffeur for the US Embassy. He was also a motor pool supervisor, as they say. Now, what were his responsibilities? He had to manage the other drivers. He had to supervise their timekeeping. He helped them with the training. He sort of covered general health and safety. He was involved in the delivery of official documents and passports and sealed packages. Sometimes he had to check their contents for accuracy. He also delivered driver familiarization training for new US drivers. Now, the main reason for that is because in the UK we drive on the left-hand side of the road, and it's important to be familiarized with that. So the test here, he's suing the US Embassy because he's been fired and he's not satisfied with that fact and he wants compensation. The question is, was his employment a sovereign activity of the United States, or was the fact that he was working as a chauffeur something that any private individual could do, and therefore that was not a sovereign activity, and therefore the US was not immune? What do you think? Views on this one? Yes. Just a second.
It depends on his contract with the embassy. If it's under the labor law, then...
So his contract was to work as a chauffeur and motor pool supervisor. It didn't say anything about whether he was engaged in a sovereign activity or not. So in this case, it doesn't really assist us. It's a good question, because if he'd been employed in a diplomatic role, it would be very clearly immune. But he was in that gray zone where he's a local hire, and it really depends on the nature of what he's doing as to whether it's commercial or sovereign.
Not immune.
Do you have a view on whether it was a...
Not immune, I think.
Not immune. So you think this is more of a commercial activity. And what facts here lead you to that view?
Because it's not a diplomat contract.
Not a diplomatic contract. Well, remember, we're looking at the activity as well, not just the contract. But you said you don't see these as diplomatic activities.
He's local, right?
Yeah.
And I think he goes under the local law.
Well,
Law.
this test, when he's suing the state, it's not him being sued, but when he's suing the United States, the test is whether his employment was a sovereign or commercial activity of the United States. So you're leaning towards commercial, private?
Yeah.
Okay. Yes.
I believe the U.S. would be immune because the employment was an exercise of the functions of the state.
So, not automatically. That is true when you're employing diplomats. When you're employing local people, the test is whether they are engaged in a sovereign activity or a commercial activity. So it's not just the hiring of them. So that's why the court had to look at what his tasks were. Looking at his task, would you still say these are sovereign?
Yes.
Okay. Is there any task in particular that leads you towards that view?
So the chauffeur was hired to carry out the functions of the U.S. Embassy. So I suppose that would be an extension of the functions of the sovereign state.
Okay.
Yeah.
So all his work is related to the U.S. Embassy. Yeah. Okay, great. And we have another intervention here. Okay.
Thank you. I think the answer is immune.
Okay.
Because, as we heard from the discussions, like many people are making the difference between a diplomat who is sent by his country and the local agent who is hired by the embassy within the country, even if he is holding the nationality of his own embassy. Once he's working with the embassy, but he's living in the host country, he's a local agent, and in normal life, he doesn't enjoy complete privileges and immunities as a diplomat.
Yeah.
But once he exercises the function of a diplomatic or consular mission, he enjoys the same immunity. So I think the act is immune because I'm going to refer here, for example, let's say to diplomatic mail, it's immune. If we hand to a pilot a mail that he has to deliver,
Yes.
all activities that pilot does from once he got the mail until he delivered it
Yeah.
is immune.
Yeah.
And his immunity ends once his mission ends. So technically here, the immunity is to protect the sovereign act. So he's representing the act of the country, so I think he's immune.
Okay, so we have another vote for immunity and focusing in particular on the delivery of the official sealed documents here. We have three more interventions here. Thank you.
Good morning. Thank you very much. I just want to add to gentleman's answer that the chauffeur not only delivered but also sometimes checked the content for the accuracy. So he might be familiar with the content of the emails or other packages or passports or documents.
Yep.
And also he was managing the drivers, not only the drivers, but also timekeeping, appraisal. So it means that he knows the routes of the diplomats, where they are going. So I think in this case, it's immune.
Okay, we'll see what the last two interventions say, but we are leaning towards immune here. Yes?
I see that there are diverse opinions. I agree with the colleagues that believe that the embassy is immune. In this case, there's a private claimant taking the embassy to court.
Yeah.
An embassy cannot be taken to court. It's under the Vienna Convention on the Law of Treaties of 1961.
Yeah.
So I think that's the way it is.
So we need to. This is part of the patchwork. So the Vienna Convention doesn't actually regulate. It says a lot about the immunities of the embassy, but it doesn't actually regulate when the embassy can be sued or not as the state. That is regulated by the UN Convention on State Immunity and customary international law, which has a provision on employment contracts which says a state can be sued for an alleged breach of an employment contract if it is of a private law or commercial nature and it doesn't touch on their sovereign activity. But the extension of your argument could be because this is an embassy carrying out diplomatic activities, that puts it in the sovereign category. And yes, next to you we have your colleague.
Good morning.
Good morning.
I'm going a bit against the wind here.
Very good.
So, in my opinion, I think it's the state is immune. So I think they can.
You think it is not immune?
Not immune.
Yeah.
Because looking at the tasks of the claimant, from my point of view, it's very managerial, and the tasks are not related to any sovereign activities. It's really delivering packages, managing, and even when it comes to managing, it's really schedules and drivers, etc.
Yeah.
So it doesn't have really a diplomatic weight from my point of view. The packages are sealed.
What about the point of your colleague behind you who said that the driver sometimes checks the accuracy of the contents?
Well, I think from my point of view, when they said sometimes checks contents and their accuracy, it's still in the delivery kind of point of view, as in checking who he is delivering to, what is he delivering to, stamps, etc. So for me, it doesn't really have a diplomatic or sovereign weight.
Yeah.
And that's why I think the state is...
No, I encourage different views. I'm not choosing easy cases for you. That would be boring. I'm choosing the borderline cases. So in this case, the court actually found immune. But I think this is just the second instance. I think this is going to be appealed. So this is not the final word on this set of facts. So the court found that his role had a mixture of private and sovereign elements, but it was sufficiently connected to the sovereign activities of the US mission. And it's interesting, in the reasoning of the judgment, they didn't really emphasize the delivery of the official packages or the checking of the contents, which I agree with you sounds very sovereign to me. Instead, they emphasized that he was coordinating 3,000 transport decisions a year and was involved in the road safety training. And they thought that was what lent it more of a sovereign element. So for now, they have found that he is immune. Okay, another employment case. This is against the Spanish embassy this time. Now, the claimant worked at the Spanish embassy in London. She started off her role as the social secretary for the ambassador, so she's scheduling all of the dinners and diplomatic appointments for the ambassador. She occasionally handled confidential documents for the ambassador. She then was moved into a role as an administrative assistant, where she handled sealed documents for the diplomatic bag. And then she became protocol officer, liaising with the Foreign Office of the United Kingdom on staff arrivals and diplomatic vehicles. And then she was fired, which is why she's suing the Spanish embassy. So what do we think about this one? Different role, working closely with the ambassador. Is this sovereign activity and then immune, or is it a commercial activity? Yes.
Yeah, just I would like to raise a question out of this
Yes.
one. If she has been asked to come to the court and for a witness statement,
Yeah.
does she has immunity or not?
So the claimant.
The claimant, yeah.
No, she doesn't have immunity from giving a witness statement. That's only for diplomats, and that is under the Vienna Convention, where they can't be called as a witness.
Even though if she has sovereign information, would be given to the court, breaching the immunity of.
Well, no, that's a very good point. So what could happen in that scenario is that Spain could challenge that and say that her witness statement needs to be redacted or kept confidential. So only the judge can see it. So there are procedures for that if she's trying to share confidential information. But she herself would be giving a witness statement. The contents, though, could be challenged.
Okay.
Yeah, and that does happen quite regularly in cases. But do you have a view on whether she's engaged in a sovereign or commercial activity? Is Spain immune or not?
No, she's not immune.
Not immune?
Yeah.
Why?
Because the nature of the work she has been given is not, it can be done by, it doesn't have, even though it's a bit difficult because she has like a very confidential, access to the confidential information, which kind of given her give the embassy immunity of its kind of state acts.
So now you're leaning towards immune.
Yeah, kind of.
Yeah.
It is a bit tricky.
It is borderline.
Yeah.
Other views? Immune? Non-immune? Yes. Got 2 here, and then I'll tell you.
So I'm just thinking, this is quite confusing, but I feel she's not immune because the nature of her work doesn't seem to be strictly sovereign in function.
Yeah.
More of not substantively sovereign, but seems quite procedural in nature, which could be done by others as well. Like she is working as an assistant at times, administrative assistant. Also, mostly just scheduling appointments, I think, and just meeting with people. So I think she is not immune.
Well, the state is not immune.
Yeah, sorry, the state is not immune.
Would you, with the previous case with the chauffeur, would you have also said not immune?
No. In his case, I thought the state was immune because at times he was also checking the contents of the sealed
So for you,
envelope.
that was...
And in her case, though it's written she's handling sealed documents, but I don't see that she's also checking the accuracy of those documents anywhere. So I think that's where
for you, that's where to draw the line.
Yes, yes.
Okay. And point here.
Well, I have a little question. What does it mean, like, occasionally handled confidential documents? Does it mean that she actually had not any functions regarding this, but because she worked there, she time to time had access to confidential documents, although she has not to do it?
Yeah, no, that's a good question, and it goes to your colleague's point about what is she actually doing with these documents. So she's receiving them, filing them, transferring them. She's not writing them, and she's not checking them.
So she's not aware of the content.
She's physically moving them around or digitally moving them around places, but she's not checking their contents for accuracy.
But she might be aware of the content, right?
Yeah.
Okay, I'll go just with non-immune.
Non-immune. So we've had 3 non-immune here. So you're starting to think like English judges, because they also found she was not immune. Well, Spain was not immune. And they said not everything, she was working with a senior diplomat, she was working with the ambassador, but not everything done by an ambassador makes it a sovereign act. So they found the kind of level that she was working at, administrative assistant, social secretary, protocol officer, in handling the duties on behalf of the ambassador, were not acts in the exercise of sovereign activity. So this is also a case that's at the Court of Appeal level. We'll see if it goes to the Supreme Court, so it may not be the final word. But we can see just very small changes in the facts change the outcome of the immunity of the state in these employment-type cases. And these are actually probably the major source of litigation between embassies and individuals in various jurisdictions. Okay, so now we're going to move to a slightly... Oh, you have a question? Please.
Thank you. Professor, for both cases,
Yeah.
I was just wondering if the courts gave more weight to the functions of the claimants rather than contracts that they signed.
Yes,
Okay.
they did. They did, and that's a good question. So the contracts are very vague. The contracts do not specify necessarily in any detail the roles that they're doing. And in the case of Ms. Lorenzo, her role changed over time, which didn't necessarily lead to new contracts. So the court was taking evidence on what their actual functions were.
Thank you, Professor.
Thank you. Okay, we're now going to move to a different topic under state immunity. Oh, we've got a question up the back there.
Thank you, Professor. I actually have a question regarding the consistency between two different courts, because I noticed that I think there were two different domestic courts trying to make a judgment on the basis of international law. I was wondering, as you mentioned, indeed there are slight differences between the facts or the content of the responsibilities itself, but also I was wondering, do you think it could also be the case that just two different courts have different views on what fell under the types of sovereign acts? Because I feel like the line is quite vague in this content, because they also have some responsibility for checking the rules, or for example, for the second case, for staff arrival, some things like that could also concern about security issues as well.
Yeah. So there are two different courts. The first court, which dealt with the chauffeur, is a lower level court than the court that dealt with the administrative assistant. But at the same time, they didn't say that they were contradicting each other. I think the way these judges would explain the different outcomes is on the facts of the case. So it's exactly as you say. There's a fine line, and that fine line may be varying between the courts, not because the law they apply is different, but because the facts of the case differ. And we'll see if these cases go up to the Supreme Court level, if they agree with that, those differing outcomes. But I think at the moment, the courts don't think that they're taking different views on the law. They just think they've got different facts before them.
Thank you very much.
Yes, and
So, Professor, I'm interested about the fact that in the second case, the claimant actually communicates or liaises with the FDO, right? With the FCO in London. While in the first case, they're only delivering documents, they're only communicating about the packages that will be delivered.
Yeah.
Wouldn't liaising with FCO directly result in the textbook definition of a sovereign act, because you will be representing the embassy, right? Or at least the ambassadors.
I mean, that is a good argument on behalf of the embassy. I think the counter-argument to that, which Ms. Lorenzo made, is that she was just liaising with them about really routine matters, nothing to do with confidential information. It was, this is our diplomatic vehicle. It has this license plate number, and our staff will be arriving at this time on this flight. So it was those kind of issues that she was liaising with rather than the content of anything sensitive. So I think that was where the court drew the line. But I agree with you. The minute she starts to be the kind of face of the embassy for these kind of contacts, it does tend to lean towards more sovereign activity. Okay, we're going to move now to a different question under state immunity, which is whether there is a human rights exception to state immunity. Because we've been looking at an exception based on commercial or private law activity of the state. But there's been a number of cases that have argued that there should also be an exception to state immunity for grave human rights violations. So I'm coming back to the first case that I spoke to you about in that first slide between Germany and Italy, the jurisdictional immunities case at the International Court of Justice. Now, this was a case that arose from World War II, where the Nazis had captured Italian civilians and had put them to work. You see that in that old photo there, where that was slave labor by Italian civilians enforced into that by the Nazis, taking place in Italy during the Second World War. There was also mass graves found with Italian civilians, so there were crimes against humanity of mass killing, and there were also allegations of torture. So very, very serious allegations against Germany. In the 1990s, so many decades after these events, Italian nationals started suing Germany in the Italian courts, saying that they never received compensation for these very serious violations, and they wanted compensation. And the Italian courts, all the way up to the top court in Italy, the Corte di Cassazione, found in favor of the victims. And they said Germany does not have immunity for these serious human rights violations. And Germany owned and still owns a number of properties in Italy that it uses as cultural centers and so on. And the Italian court started ordering the seizing of these German properties so they could be sold and the proceeds given to the Italian claimants. So Germany brought this case to the ICJ and said, we admit that the Nazis did all of these terrible crimes. However, there is no human rights exception to state immunity. So we are immune from all of these Italian cases that are trying to take our property. And then Italy counter-argued, saying, no, there is a human rights exception to immunity. So that was the direct question before the court. And Italy made its argument sort of along three lines. They said there is a human rights exception to state immunity for serious violations of international law that amount to war crimes or crimes against humanity. They said, if you don't accept that, ICJ, then we at least say that there is an exception for the so-called jus cogens violations, the most important human rights from which no derogation is permitted, which includes slavery. And then their third argument is this is a last resort. These victims didn't qualify for any of the compensation funds that Germany set up after World War II. They have no other way of receiving compensation for these harms. So they made those three arguments before the International Court of Justice, and the court found that there was no human rights exception. So Germany was immune, and all of these Italian cases that had been trying to hold Germany accountable for these violations and sell their property were in violation of the rule of state immunity. So the court's reasoning was that under customary international law as it presently stands, a state is not deprived of immunity by reason of the fact that it is accused of serious violations of international human rights law or the law of armed conflict. And they said, we realize these are very grave crimes and very grave allegations, but we're not dealing with the same thing. This is the reasoning of the court. There's no conflict because immunity is a procedural rule that allocates jurisdiction, and the rules against torture and slavery and mass killing are substantive rules. And they're not dealing with the same thing, so one does not displace the other. So as you can see here, they say the rules of state immunity are procedural in character and confined to determining whether or not the courts of one state may exercise jurisdiction in respect of another state. They do not bear upon the question of whether or not the conduct was lawful or unlawful. If we're thinking about our rationales for immunity that I set out at the beginning, this is really the rationale of sovereign equality that's being emphasized here. And the court went on to say it was only addressing the immunity of the state itself, and it was leaving open the question of whether that immunity might apply in criminal proceedings against an official of a state. And we're going to be coming to that shortly. So we have a very clear decision of the ICJ saying no human rights exception to state immunity. So that was in 2012. In 2014, we had a case of Jones and the United Kingdom in the European Court of Human Rights that raised this question again. And this time before a different court, but another international court. So these were 4 British nationals who alleged that they had been detained and tortured in Saudi Arabia, and they sued Saudi Arabia and its officials in the English courts. At every stage of the English proceedings, the English court said that Saudi Arabia had immunity. So they upheld Saudi Arabia's immunity. They said that these were state officials discharging their official duties, and the state was entitled to claim immunity for their actions. So when the case came to the European Court of Human Rights, this time these claimants were suing the United Kingdom. They weren't suing Saudi Arabia. They were suing the United Kingdom for saying that by upholding immunity, the United Kingdom had denied their right of access to justice. So we had this question again before a court, is there a human rights exception to state immunity? And the court said no. They upheld the immunity of the United Kingdom and said that it had done nothing wrong by upholding the immunity of Saudi Arabia. And they emphasized the ICJ case in 2012, saying that nothing has changed in the intervening 2 years. There was no accepted jus cogens exception to state immunity, and the decision by the English courts to uphold the claim to immunity did not amount to an unjustified restriction on the applicant's access to court. The European Court also found that the immunity applied to the state officials, not just the state itself, because they said measures that reflect generally recognized rules of public international law on state immunity could not be regarded as a disproportionate restriction on the right of access to court. And finally, they said the state's right to immunity cannot be circumvented by suing the officials instead of the state. So we have two judgments there from two international courts, the ICJ and the European Court of Human Rights, that say there is no human rights exception to immunity of the state. We're going to come to officials in the moment. Any views on this? Any comments on this? Is this a positive development? Does this make sense? Is this a problematic position to take? Are there other ways of getting accountability?
Thank you, Professor. I actually have one question because I noticed the recent ILC report regarding to the immunity of officials have this draft of Article 7 that listed several crimes that should be considered as rational material to the immunity itself. So my question is if it is like as said in these judgments that there is actually no conflicts between use cogens or some types of substantive law and the procedural law. Why would ILC still consider the necessity of listing such crimes that majorly overlap with the use cogens for the immunity of officials? I mean, of course, they have quite different probably functions on rationale between immunities to the officials and the sovereign state, but still I'm just a little bit wondering if you can,
Yes, and we're going to be coming back to draft Article 7 in a couple of slides. But just to answer your question, why are we seeing sort of different trends for the state and for state officials? Well, first of all, what the ILC is working on is an exception to the immunity of state officials, as you said, immunity rationale materiae, so not the top state officials, not the head of state, head of government or foreign minister, but other state officials, and only in respect of a small number of crimes. I think what and I can't speak on behalf of the International Law Commission, but my interpretation from what the Special Rapporteur reports and what the discussion in the ILC has said on this is not because they deny the procedural substantive distinction. They don't deny that. That remains as the ICJ said it. But because they believe over time state practice, including in making treaties, has shown that states do intend to take away the immunity of not the highest level of officials for these categories of crime, because these are crimes where states have agreed to the extraterritorial exercise of jurisdiction. And it wouldn't make sense, this is the reasoning of the ILC, members who support this, it wouldn't make sense to criminalize these activities and extend extraterritorial jurisdiction, and even in the case of torture, for example, to say this activity can never occur without the involvement of a state official, if at the same time you granted officials immunity for those crimes, because that would mean there would never be a prosecution of those crimes. So that's the reasoning. So it's based on an evolution through state practice and opinio juris, not because there's a difference between procedural and substantive rules in international law. Any other views on a human rights exception to state immunity? Yes.
Well, in my opinion, I think the move is a welcome move towards the protection of human rights, especially because political leaders in many countries, especially in countries, I don't know about the other continents, so I can only speak about the continent I'm familiar with, which is Africa. Yeah. There are a lot of political leaders who take advantage of their positions to oppress their opposers, to oppress democratic rights, to overturn constitutions and things like that. And whereas justice to the people looks elusive, with this kind of exception, there is hope that one day when this person eventually leaves the seat, they are going to face the consequences for their actions. Yeah. And that in itself sometimes, when these things happen and there's a lot of noise and the outside world says we are looking and reminds of the consequences, sometimes it acts as a deterrence, and sometimes it slows or alters the kind of actions that these people take, and sometimes they are less aggressive than they would be. So for me, I think it is a welcome move, especially with regards to human rights. And no matter how sovereign you are, human rights are unalienable, and no one should have the power to take away the rights of another arbitrarily.
Thank you very much. And that leads very well now into our discussion of whether there's a human rights exception to the immunity of state officials, which, as you have already anticipated, we see an evolution in the approach towards accountability. So while the state itself remains immune, according to these cases, when it comes to state officials, we see more variation. And this comes back to another theme that I mentioned at the beginning, that this is an area of law that is in flux. It is evolving, and it's national courts often that are part of that evolution. So just to recap, before we get into the ILC's work, how we think about the immunity of state officials. And there's a little bit of Latin here. So on the left-hand side, we have retione personae, or personal immunity. And that is the immunity that those top three officials have. So the head of state, head of government, who are sometimes the same person, as in the United States, or they're sometimes split into two different roles, as in the United Kingdom, and the foreign minister. Now, they have very extensive immunity while they are in office, and it is justified because they are said to embody the state. That's the representational justification for immunity. Now, it applies during their time in office, and it applies to both their official and private acts. On the right-hand side, we have immunity rationae materiae, also known as functional immunity, which, as its name suggests, is justified by the functional rationale for immunity, meaning that we give this immunity so that people can perform their roles without being hindered in their activities. This applies to state officials generally. It doesn't matter if they are the mayor of a small town of a state or whether they're the Minister of Defense. They have this same immunity, functional immunity. And it continues to apply after they leave office, whether they resign, retire, or they're fired. However they leave office, they continue to have this immunity, but only in respect of their official acts. That's the big difference between personal immunity and functional immunity. Personal immunity for those top 3 officials is for both official and private acts, whereas for other state officials, it only applies to acts in their official capacity. Now, that doesn't mean it's only their lawful acts. It's official acts, not lawful acts. So if it was an unlawful act, but it was in their official capacity, then they will still be immune. Okay, so that is where we're looking at in terms of different categories of official and the type of immunity they involve. When we start talking about a human rights exception, the view of the International Law Commission is that the people who enjoy personal immunity have no human rights exception to their immunity. They're like the state, because they embody the state, there's no human rights exception. However, for other state officials, and this is the draft Article 7 that we've already alluded to, for other state officials, there is an emerging view that there are human rights exceptions to their immunity. And the draft Article 7 that's currently before the International Law Commission says that an ordinary state official is not immune from the exercise of foreign criminal jurisdiction for the following crimes: genocide, crimes against humanity, war crimes, apartheid, torture, and enforced disappearance. Note that aggression is not on that list. That was debated in the ILC, and for now they've decided not to put it on the list. Now, there's varied state practice in this area, and as I said, this is just a draft article and it's not yet finalized by the International Law Commission, but it has been debated several times over the years and states have had the opportunity to comment on it. But in terms of recent state practice, we've seen varying outcomes from domestic courts where state officials are being sued. So in France, former US officials, including former President George W. Bush and former Defense Secretary Donald Rumsfeld, were accused of engaging in torture in Guantanamo Bay. The French court found that they were immune, no human rights exception. In Germany, former US officials were also accused of the same crime, and they were also found to be immune. In the Netherlands, an Israeli defense minister accused of an airstrike in Gaza from 2014 in a civil case was found to be immune. We're going to come back to that case in our second session. However, an Afghan soldier accused of war crimes in a Kabul prison in the 1980s was found to be not immune. And the German courts actually referred to ILC draft Article 7 and said that now represents customary international law. So we're starting to see some different views emerge on this type of exception. In the International Law Commission and in the 6th Committee of the General Assembly itself, we're seeing a variety of views. I don't think we have a consensus yet. So some states have rejected draft Article 7. Such in 2023 in the 6th Committee debate, UK, Germany, France, Australia, Russia, and the United States, as well as Israel last year, said that draft Article 7 does not represent customary international law. However, several states have welcomed it, including Austria, Ireland, Lithuania, Poland, the Republic of Korea, and Romania, as well as Colombia most recently. So we're seeing these divided views. We'll see what happens in the next meeting of the Sixth Committee and the International Law Commission. And just a recent case on this question as well, which was about the torture allegations in Guantanamo Bay. This came to the European Court of Human Rights. And France was actually being sued, not the US, for the alleged torture in Guantanamo Bay, but France was being sued by the complainants for failing to do enough to prosecute senior US officials. And that question came before the European Court of Human Rights, and they found that France was immune. And they again went back to what the ICJ said in Germany, Italy, that there's no customary exception to state immunity, and they actually said draft Article 7 does not yet reflect an existing rule under international law. So if we were to summarize where we stand on the human rights exception to immunity, we can say that it's quite a clear judicial view that there's no human rights exception to state immunity. There's no human rights exception to senior state officials' immunity from jurisdiction. However, when it comes to the lower level state officials, it's possible that we're going to see some more cases like that German case that will invoke draft Article 7 and say there's an emerging rule of customary international law. Okay, we're going to shift our focus again to another contemporary challenge, which is the use of spyware by states. How many of you have WhatsApp on your phone or computer? Yeah. So with zero-click technology now, you don't even need to click on a dodgy link to have your phone turned into a surveillance device. Because Pegasus, Finfisher, Paragon, and other spyware now can access your phone just by you having WhatsApp on your phone. We're all in the same boat. Now, what happens if it infiltrates your phone? It means that whoever is operating it remotely can see all of your data, all of your photos, all of your videos, all of your emails, all of your messages, everything that you search. They can turn your camera on, they can turn your microphone on, they can turn on your location tracking, all without you knowing. It doesn't mean that your phone starts acting weirdly, that it's slower, or that you notice anything happening. It's invisible. The only way that you can find out whether your phone has spyware on it is if a professional, either within a government or there's a couple of NGOs that have this expertise, examine your device and can identify it. So this is being used more and more by governments purchasing from private companies. So I've put here, is your country on this spyware list? And that's only for Pegasus, and I think that's from a couple of years ago, so it's not even like up to date. But there's been various leaks. For example, 50,000 phone numbers were found to be on a spyware list in 11 countries. 180 journalists were found to be on a spyware list. A lot of government officials have found that their phone numbers were on this list as well. Now, how does this relate to immunity? Well, if a state has purchased this spyware and is using it to spy on individuals in another country, then there is a possibility of suing that state for its use of spyware in violation of domestic law. But the challenge here is, how do you show the jurisdictional link? This is a simplified version of how spyware works. So you have the Pegasus working station, and Pegasus is produced by an Israeli company called NSO, so that may be located in Israel, but it could be located elsewhere. But then it goes through all of these middle methods before it infiltrates your red device at the end. And this is, as I said, is simplified. It could be, many dozens of relay servers in between. And those relay servers are used to mask the origin and the data that is being transferred. And countries that host these servers may not even know that their servers are being used to bounce this spyware around the world. The Pegasus project found that there were hundreds of servers being used for this in 45 different countries, in particular Bangladesh, India, UAE, Jordan, Egypt, Saudi Arabia, Thailand, Morocco, Rwanda, and Uganda, some of the countries here today. Unbeknownst to them, perhaps, are being used to mask the use of this spyware before it finally ends up at the device being used. So the question here is, if you want to hold accountable the state that has purchased this spyware, allegedly, to use against an individual in another country, and you manage to show some kind of jurisdictional link, how do you find an exception to immunity? And the answer to that is the territorial tort exception to state immunity. And this is just one example, which is the UK State Immunity Act, but every state that has state immunity legislation, except for Pakistan, has this exception within it. It also appears in the UN Convention on State Immunity. Now, it has slightly different wording, so it may not work for all of these states, but it is a very common exception to state immunity. And it provides that a state is not immune for proceedings in respect of death or personal injury or damage or loss to tangible property caused by an act or omission in the United Kingdom. Okay? An act or omission in the United Kingdom. So if you're looking at this map and that red device is in the United Kingdom, where the spyware is being installed, where are you going to identify the act that is in the United Kingdom that will activate this exception to immunity? What's the act? It's obviously not where the orders are being given from the Pegasus working station. It's not in the relay servers, possibly in a dozen countries in between. What is the act that gives jurisdiction to the UK?
Maybe the last one?
Yes.
Agent install?
Exactly. Agent installed. Exactly. So we have the installation of the spyware, which is in the UK, and then after that, the data being exfiltrated, or the location tracking being turned on, or the microphone being turned on, or the camera being turned on. That all is also happening in the UK as long as the device is in the UK. So that's the idea that behind this, using this exception to immunity, that a state is not immune in respect of death or personal injury or damage to property caused by an act or omission in the UK. So there's been a couple of cases on this. Recently there's been the Al Masriya case, which found that the alleged use of spyware by Saudi Arabia against a critic, Ghanem Al Masriya, who had asylum in the United Kingdom, and he found that his devices had been infiltrated by Pegasus spyware, meant that Saudi Arabia did not have immunity because a computer device located in the UK by instructions from a computer operator located abroad can still be regarded as an act within the United Kingdom. And there's a number of cases like this in the UK using this exception to immunity. So this is one way in which we have a contemporary challenge of spyware and immunity law is being used. I have to say there's been similar cases in the United States regarding spyware, including to spy on the Democratic National Committee, and they have been found to be immune because under US law, it's not enough for an act to occur in the US. The entire activity has to occur in the US, and that is impossible to show with a spyware scenario. Okay, we're now moving away from jurisdiction to state immunity from execution. Now, this scenario arises when you have a judgment against a state or an arbitral award against a state, and now you're trying to get paid. Or if you're the state, now you're trying to resist having to fulfill the damages or the compensation. And that's when we start looking for different assets to potentially enforce against. So any views on whether you can enforce against the images on this slide? Can you enforce against the Mona Lisa if you had a case against France? No, why not? Ooh.
It's a global heritage of culture.
Cultural heritage.
Yeah.
That's right. Okay, we cannot enforce against the Mona Lisa. What about the other items on this slide?
Well, gold, I guess, is just a reserve of each state, so I guess it's the same like sovereignty, immunity, I guess.
Yeah.
Embassy, is it like the property of the embassy?
Yeah.
The same like property of the state?
Yeah.
Like the territory of the state, so it's also immune.
Yeah.
I don't know about the military ship, but the last one, which is simply money transfer, I guess, this is what.
So the last one with the calculator is meant to represent the bank account of the state.
What kind of bank account?
Well, that's the good question. Let's say it's a diplomatic bank account. Then no.
Yeah.
But what about the warship? Are you going to enforce against the warship? No. No, we're not going to enforce against the warship. So the clue here is all of these you cannot enforce against. Okay, these are state property in use for sovereign purposes, but you can see they fall into different categories. And thank you for being the person commenting on this slide. Okay, what about these items? Can you enforce against them? Views on this. Can you enforce against these items of the state? What is the first one? The first one is a residence. The first one is a residence in Paris.
For the diplomats?
For the first vice president of Equatorial Guinea. This is a case that went to the International Court of Justice.
Oh, it's his personal property.
Well, originally. Then Equatorial Guinea said it was their embassy. But let's just say that it's the private residence of the first vice president of Equatorial Guinea, which I have to say had its own nightclub and hairdressing salon, which is very nice. Can you enforce against that?
But it's not the property of the state.
Exactly. So yes, and that was what the ICJ found. They actually found, and the case has come back to the ICJ, but the court found that this was not being used as the diplomatic embassy at the time. Okay, the other one is the cards are just ordinary bank accounts of the state being used for purchases, procurement, not for the embassy.
Yes, maybe?
Yes. Cargo ship.
Of the state or some organization?
Of the state. Carrying cargo.
Yes.
Yes. And the diplomatic car.
I think yes.
No. But not if it was the private car of the diplomat. But if it was used for diplomatic activities, then you cannot. So thank you. Yeah, the point of this is that when we are enforcing against state property, we have one question to ask, which is this property in use for sovereign purposes? If it is, then it cannot be enforced against. If it is a property in use for commercial purposes, then it can be enforced against. So when we come to trying to enforce against state property, we see it's a higher bar. We don't have all these exceptions for territorial tort or employment or so on. We are really looking at whether either the state has consented to the use of the property for its obligations to be met under the award or the judgment, or whether it is in use for a commercial purpose. So state property in use for public purposes is absolutely immune, and you can only enforce against state property in use for commercial purposes. So let's have a look at some state property. So we have a company, Common Simpex, which has a 1.7 billion euro arbitral award against the Republic of the Congo, and they seek enforcement in France. And they try to enforce against two different properties. They try to enforce against the private residence of the Congolese ambassador to UNESCO, UNESCO being based in Paris. And they try to enforce against a Congolese government payroll office based in France. What do you think about whether you can enforce against these properties? Are these assets immune? What do you think? Yes.
Yes. For the first point, Professor, I think when it comes to the private residence of a Congolese ambassador, I would say the emphasis should be made to how the property is used. So if it is for private residence, I don't think it falls under sovereign acts or diplomatic acts. So I would say it would not be immune. But for the payroll office, since this is more of a business-related activity, it may be falling under the immunity definition.
So that's right. We see usually the residence of the ambassador would be immune, but that's if it's being used as his official residence. This was his private residence, so it was not immune, you're correct. But the payroll office, which is being used to pay government salaries, purchase government goods and so on, had a governmental purpose and therefore was immune. So this just shows you, whether your strategy is to protect the state from these claims or whether your strategy is to find how to fulfill these claims against state property, you have to look very carefully, again, at the facts and how these assets are being used, because you may have different outcomes. So let's do another one. This was a case between Zhongshan and Nigeria, which concerned two properties in the UK owned by Nigeria. And Zhongshan, who had the $55 million arbitral award, wanted to enforce against property that Nigeria owned in the UK for commercial purposes. Now, these properties were in Liverpool, which is a city to the north of London, and the Nigerian ambassador issued a certificate saying that these properties were in use for sovereign purposes, that they were being used for consular residences. Now, let's just put ourselves in the shoes of the claimant for the moment, okay? So you're representing Zhongshan, and you're trying to get paid this $55 million arbitral award. And you've just, in your case, received the certificate from the ambassador saying, no, these are consular premises, you cannot use them for enforcing against because they have a governmental purpose. Do you just give up and walk away and say, okay, this isn't going to work? What what could you do? Thinking as the claimant here. Do you just accept what the ambassador has said? Sorry? Yeah. Click, just wait for the microphone. Thank you.
Hello, Professor. I mean, you should try to argue maybe the statement is not correct. Maybe some investigation about the uses of the building. What is the purposes of all of the residents there? Just a way to find, to get this statement to check if it is correct or not.
Yes. How would you, in very practical terms, how would you investigate this?
Maybe through other diplomatic ways. Maybe other states can, embassies can intervene or cooperate.
Okay.
Or even the internal police here in the UK.
Yeah. So you could go to the authorities?
Yes.
But very good instincts there to not just accept the certificate and to look a bit further.
Yes.
So in this case, the claimant's lawyer actually just got on a train to Liverpool and turned up at the address to see what are these buildings. And they found that that's the building. That is the building. Does not look like a consular residence. And they knocked on the door, and the person answered the door, and they said that they were renting on commercial terms from Nigeria. They were a private citizen. They were not a consular official. They were actually quite upset because they had asked the landlord to fix various things, and the landlord had not done so, so they were ready to talk about what was the property. And the evidence actually showed the properties had not been in use for 30 years for consular purposes. So this property was enforced against. It wasn't worth $55 million, however, but it was a starting point. So that's just to show you, even if the initial evidence may be that this is a sovereign purpose, there may be further investigations that could find another outcome. And what we're really looking at here is what is it intended to be used for. Okay, let's move to another contemporary challenge, which is Russian central bank assets. And back when we looked at that slide that had the gold bars on it, the foreign currency reserves, you rightly said, well, that would seem to be immune. And that is certainly the starting point for the immunity of the Russian central bank assets. But there's been various debates that I'm sure you're aware of about how these assets might be seized and used for reconstruction and reparation for Ukraine. So as you know, in February 2022, the EU, the US, the UK, and Japan, Canada, and others that had Russian central bank assets stored in their foreign currency reserves froze those assets. So that's $300 billion at the time frozen. About $200 billion of that sits in Brussels in a central securities depository called Euroclear, and also in the Luxembourg central securities depository called Clearstream. So the UK, for example, may hold some of the Russian reserves in the UK, but they're also holding them in the UK account that is sitting in Euroclear or Clearstream in Brussels or Luxembourg. So these have been frozen now since February 2022. But the next question that is being debated in various fora, from the UN to the G7 to the EU to the Council of Europe, is whether those assets can actually be seized and transferred to Ukraine or transferred to a compensation mechanism for the damage inflicted by Russia on Ukraine, which has been estimated by the World Bank most recently as about $450 billion worth. So it's already in excess of what's being frozen in these various countries. So what the potential approaches? Well, just last month, the European Council approved the continuation of the freeze. There's going to be another vote in January next year. And there's also a possibility that national parliaments could pass their own independent freezes on frozen Russian assets, which is called a double lock, which means even if the European Council decides to lift the freeze in January 2026, that individual states could freeze the assets that they hold on behalf of the Russian Central Bank. So there's basically been 4 legal strategies being debated about how you could move from freezing to seizing these Russian central bank assets. And I have to say, all of these have problems with them. There is no silver bullet here. But they are all being debated as possibilities, and some of them have even led to legislation for the seizure of Russian central bank assets. So the first one is you just avoid immunity altogether. Immunity applies to court proceedings. So if you seize those assets and transfer them to Ukraine or a compensation mechanism through executive or legislative action, then that would not be subject to immunity because there's no judicial process involved. It doesn't mean it would not be subject to international law because there would still be protections for sovereign property, the notion of sovereign equality, but it would not be subject to the state immunity rules that we've been talking about. So that's one option, and that is actually an option that's being pursued in some of the legislation, including the US Repo Act. The second strategy is countermeasures in international law. So a state transfers the Russian central bank assets to Ukraine and says, yes, this breaches international law because usually these assets would be immune, but we say this is a countermeasure, which is a circumstance precluding wrongfulness under international law because it is designed to induce compliance with Russia's obligation to pay reparation. This is one of the more popular strategies that's being considered at the moment. It's one of the strategies that lies behind, again, the US Repo Act, but also Estonian and Canadian legislation on seizing assets. The third option is we change customary international law. We get enough state practice and opinio juris to change the law, just like we've started to do in terms of the human rights exception for state officials. And we say, in very particular circumstances, maybe where the General Assembly has determined there's been an act of aggression, there may not be immunity for state property. The final strategy is an argument that when it comes to international judgments, they can be enforced against state assets. And just a week and a half ago, we got a judgment against Russia in the European Court of Human Rights, where they have not yet specified an amount of damages, but it's the case brought by Ukraine against Russia. And that could potentially lead to the European Court of Human Rights awarding hundreds of billions of dollars to Ukraine against Russia. But that will still take a couple of years to be determined. But we have the possibility of a judgment that will confirm damages. So these are all the sort of international law strategies. As I said, they've got pros and cons and varying amounts of support between states. There's also been some very creative ideas about how to start transferring some money to Ukraine while getting around the immunity of central bank assets. So there's been an argument, and this has actually led to the G7 solution, to use the profit on invested frozen assets and transfer just the profit, not the principal, to Ukraine, or to have a tax on those windfall profits and transfer the taxed amount to Ukraine. There's a strategy of keeping those sanctions of freezing the assets in place until reparations are paid. That's the UK position at the moment. And then, as I've mentioned, we've got legislation in the US, Canada, and Estonia as well. The G7 has taken an approach of giving a $50 billion loan to Ukraine that is based on the income from the frozen Russian assets, which is about 3 to 5 billion a year. And those payments began in October 2024, and each loan will enter into force as of end of June. So you can see here, immunity is a bar in terms of international law to transferring those foreign currency reserves to Ukraine. But in the face of huge cost being borne by Ukraine and the existence of these assets, we're seeing various creative solutions to try to transfer at least some of the money to Ukraine to help with reconstruction and reparation. Okay, we now come to our final topic, which is diplomatic immunities. And a really specific example under diplomatic immunities, which is diplomatic immunity for modern slavery. So diplomatic immunities, as we know, are quite extensive. They are based on the Vienna Convention on Diplomatic Relations from 1961, and they are really based on protecting the dignity of the diplomat and ensuring that he or she is able to exercise their functions. So when it comes to the diplomatic, the structure of diplomatic immunity, we have absolute immunity from criminal proceedings. A diplomat cannot be prosecuted, even if they murder someone in the street in a foreign country, they cannot be prosecuted. The only scenario in which they may be prosecuted is if their state waives their immunity. They can, of course, be prosecuted back home in their country, but not in the state where they are posted to as a diplomat. When it comes to their non-criminal liabilities, so their civil proceedings, there are 3 exceptions to diplomatic immunity. So a diplomat is generally immune, but he or she will not be immune for an action related to their private real estate, for an action related to a will and testament, that's an action relating to succession. These are very narrow. And the third one, an action relating to a professional or commercial activity outside of their functions exercised in the receiving state. So this was originally thought about as a diplomat running a restaurant on the side of being an ambassador, or one of the scenarios given in the travaux préparatoires for the Vienna Convention is if a diplomat is a qualified doctor and because he or she is not busy enough as ambassador, decides to start running a clinic for profit alongside their role as ambassador. It would fall within this exception. But the question in the case I'm going to talk to you about is whether modern slavery could fit within this exception. So this is the case of Basfaran Wong, which was in the UK Supreme Court a couple of years ago. Now, what is the problem that this is tackling? Human trafficking is the 3rd largest criminal industry in the world, behind drug trafficking and trafficking in weapons. At the same time, many of the people who are trafficked are being trafficked into forced labor, domestic servitude, and other forms of modern slavery. The total illegal profits from the use of forced labor is estimated to be $150 billion a year, and the Global Slavery Index estimates that 50 million people right now around the world are living in modern slavery. So this is a huge problem, and this case is just one tiny aspect of it, but the context is important to show that this is a pattern. So the issue in this case was whether a diplomat's alleged modern slavery of their domestic worker in London was a commercial activity outside of their functions. And this had never been directly dealt with before. As I said, when we thought about commercial activity, we thought about a diplomat running a restaurant or running a clinic or engaging in a sort of job outside. And here it was the alleged exploitation of a domestic worker. So let me give you the assumed facts, because when you do an immunity case, because it's about the immunity from jurisdiction, you deal with it on a preliminary basis before you get to the actual investigation into the facts. So a Filipino domestic servant came to work for a diplomat in London. Her contract, which she signed, which led to her visa giving her the right to work in the UK, said that she would work 8 hours a day, 50 hours a week, 16 hours of free time each day, which includes sleeping, of course, 1 day off per week, 1 month off per year, that she would have somewhere to sleep, and that she would be paid the national minimum wage, which at the time was around £10 an hour in the UK. On the assumed facts, what she alleged is that she had to work every day from 7 a.m. to 11:30 p.m., that she was made to wear a doorbell on her person so she could be summoned 24 hours a day. She was only permitted to eat leftovers. She was not allowed to leave the house. She was not allowed to contact her family. She had to sleep in a cupboard with the suitcases. And in 21 months, she was paid a total of £1,800. Now, she did not sue for human rights violations because, as we've seen, there is no human rights exception to state immunity, and there's certainly no human rights exception to diplomatic immunity. So she sued for breach of her employment contract because she said her conditions were not meeting the conditions that she had signed and that she got her visa on the basis of. And she said that the exploitation of her by the diplomat on the assumed facts was a commercial activity outside of his functions. And this went all the way to the Supreme Court in the United Kingdom, and they found that it was a commercial activity outside of his functions. So there is an exception in the UK for alleged modern slavery by a diplomat, and that will fall within the Article 31 exception for commercial activity. One of the important points here was the reasoning about profit, because he wasn't selling a good or running a restaurant or running a nail salon. So you weren't able to say he made X amount of profit on top of what he paid for in terms of costs. So here the profit had to be the value of her labour versus the £1,800 that she was paid over 21 months. And the majority of the court said that the diplomat had made a profit even though no money changed hands. They said the forced labour of the claimant gave the diplomat a substantial financial gain, not in cash, but in money's worth, and that this had been a systematic activity carried out over a significant period. So they said this is a commercial activity practiced for personal profit. Even if you couldn't show that profit on a balance sheet, it was profit in terms of what she would have earned if she'd been paid the national minimum wage for that number of hours. So we have covered a lot of topics in this time. Before I summarize, yes, question over here.
I have a question with regards to the case you have just discussed. Compare it to the recent case still in the UK of a UN judge whom I presume had diplomatic immunity, which was stripped off. She was also a Ugandan judge. Comparing the two cases, why would, since the case with the Ugandan UN judge was a criminal case in nature, why was she tried in the UK and the matter was not referred to Uganda? And secondly, I'm not very sure whether she had diplomatic immunity. If she did, was it stripped off?
Okay, thank you. Yes, I know that case because it happened in Oxfordshire. So she did not have diplomatic immunity. So she was not based in the UK as a diplomat. So you're right, she was a part-time UN judge, and the immunity that she had as a UN judge did not cover her activities in the UK when she was in her private capacity. So there was no stripping of her immunity, it's just that there wasn't an applicable immunity at the time. It didn't fall under the diplomatic immunity, which she didn't have, and then her UN judge immunity was more restricted to her activities as a judge and on location. So that was why, even though some of the facts may seem similar, it was a different situation of immunity, but a good counterexample to raise. Thank you.
Just a follow-up on the same question. In your opinion, in such cases, should they be tried how do I put it? Like for this case, was it proper for it to be tried in the UK, or would it have been better for it to be tried in Uganda, considering that for persons under certain, although she may not have had the diplomatic immunity, there are persons who hold certain positions, and there are certain procedures that apply to them when they are found to be in conflict with law.
So I think for a criminal proceeding, I think given that the alleged conduct happened in the UK and the witnesses and the other evidence was in the UK, it probably made sense from that point of view for the trial to be in the UK. There could always have been an argument that could have been made on her behalf that this would be better tried in Uganda, but I doubt that the English court would have agreed to that given that most of the evidence was in the UK. I think it's also important that it was a criminal proceeding where I think rules like that are more strict, linked to the territory where the alleged conduct took place. If it had been a civil proceeding, there could have been more of an argument about where is the proper forum for this to take place. But I think given the weight of the the location of the conduct and the evidence and the witnesses, it would be hard to remove it from the domestic jurisdiction. So let me just summarize the end of this lecture and we'll go into our break. As we've seen, this is an area of law under pressure, that there's a lot of contemporary challenges, but we continue to see these sort of common themes of sovereign equality, of representation, of the need for balancing the functioning of government officials and representatives with the growing awareness of human rights and accountability. At the moment, we don't have a human rights exception to state immunity or for the immunity of the top state officials. We have varying practice on the immunity of other state officials, but we've also seen how existing exceptions like territorial tort, like the commercial activity exception, may be used to promote human rights in certain cases. So with that, we'll go to our break. We'll start again at 5 past the hour. And have your coffee, because in the next session, we're going to be interacting a lot more on a lot of tricky cases. So thank you, and I'll see you in 20 minutes. Thank you.